Hey everyone, my name is Ruby Powers with Powers Law Group. We're going to talk about, can my 21-year-old U.S. citizen child petition for me? This is a common question, get asked a lot. We're recording this, providing this in English and in Spanish. So I am board certified in Texas with the immigration, and I've been practicing for 16 years. The law firm is 15 years old, and we just wanted to be a resource for you. This is a hot topic. A lot of people ask this, and a lot of people wait till their child is 21 and then have a consultation. And I really wanted to get this information out there because there's a lot of things to consider. Don't wait until the last minute to find out that you need to do some more research or maybe you're not eligible. So this doesn't take the place of legal advice. This is information, just want to be a resource, but please have a consultation to evaluate your particular situation. Now, an immediate relative, the gist of it is has certain better protections, and it allows the visa to be immediately available. So immediate relatives of U.S. citizens include parents. It also can include step parent, and spouses and unmarried children under 21. So what we're really talking about here is you would be the beneficiary in this conversation, and a petitioner would be a child, U.S. citizen, 21 or up. And the U.S. citizen child can petition for step parents as long as that relationship was basically meaning that marriage happened before the child turned 18. So that's really important. Now, if you, one thing that a lot of people need to know is that there's either adjustment of status, which is when you have the visa available and you're adjusting here in the United States, that goes with USCIS, or there's consular processing, which is when you're working with the Department of State, or a combination of USCIS and Department of State. And usually you would only be doing the consular processing when the parent is outside of the country, or needed a waiver for some reason and couldn't adjust in status in the United States. So, okay, why would a person need to go outside of the country to do the consular processing? Well, a lot of it stems from, do you have a legal entry? Now, so with very few exceptions, which we'll go over in a second, you need to have entered legally to be able to do adjustment of status. Now, there is this concept of a parole in place that this is being talked about under the Biden administration, announced as a possibility that we believe we should find out sometime soon this summer more about these details. And they're saying that it would be granted on a case-by-case basis, but this would allow individuals, if they were eligible for it, to be able to, if they have a visa available, especially if it's immediate relative and that could waive the unlawful presence, they'd be able to adjust without having to leave. Now, but you definitely do need to have a legal entry to be able to adjust. So a legal entry would be, the way the language says is admitted, inspected, or paroled. So admitted is usually easier because it's like a stamp in your passport or some type of I-94. Inspected, this is when sometimes we use the wave through situation, but you've been someone at the airport or border inspected you. Or sometimes there isn't proof of that, but so that's why there's the matter of quilantan. So then the admitted, inspected, or paroled, which is the other one where an individual could be paroled in. Now, if you don't have a legal entry for adjustment of status purposes, we would have to explore other options. Maybe you could apply for military parole in place if you have a spouse or child in the military, Ready Reserve. There's a list of military requirements. The other could be you could have DACA and applied for advanced parole. The other could be you are grandfathered under 245I. The biggest thing to remember there is April 30th, you had to have an I-140 and a I-130 labor certification for you, or if you were a derivative of a case by April 30th, 2001. There also could be the potential for a provisional waiver, but that doesn't mean you get to adjust status. Since the country, you'd have to leave the country, but you'd have to have a U.S. citizen or legal permanent resident spouse or parent. Spouse, or the beneficiary would have spouse or parent, and what would that, not a child. And so that's a big misunderstanding on this. Cancellation of removals in immigration court. a lot of cases are getting dismissed and not moving forward. So this has been a bit hard to obtain. And also there's a backlog in visas. The other thing would be U visa, which is taking about 10 or 15 years. Right now, the administration is allowing people who are in the US to wait for the U visa, but in the prior administration, they were not allowing people to wait. And then there also could be some other reforms. There's also T visa, U visa, we said U visa. But the thing is that for the most part, if you did not enter legally or you do not have a matter on inspection or admitted or paroled, then you have to find one of these other exceptions, and you might still have to go through consular processing, or it might take a while. Uh, Now, in June 17, 18 of this year, Biden administration mentioned that they were considering doing a parole in place process. We don't have all the details, but the biggest idea is it would impact mostly 500,000 people that are immigrants that are married to U.S. citizens. They had to have been married to them as of June 17th. The person had to have been a U.S. citizen as of June 17th. But the other thing is the individual had to have been the immigrant had to be here for 10 years as of that date. Now, we're really not talking about that with here, because if that person did have those qualifications, they would just have their spouse petition for them for the most part. So, and it's important to know who can petition for whom, but we're talking about if you could have your US citizen child, 21 or up, petition for you, which would make you an immediate relative. And really what this comes down to is, did you enter legally, or do you meet one of those exceptions for that legal entry? Or are you going to have to do consular processing? If you have a legal entry and also how many legal entries do you have? That's another thing to consider, but let's pretend you have one legal entry. You came on a tourist visa and your child is 21 and a US citizen, and then they could, if you don't have any other inadmissibility issues, which we'll mention in a second, you could do what we call you could have the I-130 and the 485 all together. But if you did not have a legal entry or don't meet one of those exceptions, you would do the I-130 and then potentially consular processing. But it's important to note that if you had overstayed or you had multiple entries, you have to consider one legal entry and overstaying, you could be fine with an immediate relative, which is what we're talking about. But if you've entered, you overstayed, you left, you entered, this is where we're going to have a problem area, because it's very likely a permanent bar. So this is what I usually find when I'm doing consults, is that the individual has a bit of a unique situation of entries and exits, and so then that is an issue. So things we ask are, how did you enter, all the ways and all the different times, where do you live, has anyone petitioned for you, is the visa available, did you ever work unlawfully, because that can be another issue as well. Now, usually if you have an immediate relative petition, you're going to be fine, but there's some other things you need to consider. You need to look to see, do you have that legal entry? If you have to consular process, are you going to trigger a 310 or even a permanent bar? Even when you go through consular processing, they're going to be examining more things about tattoos, mental health issues, in the medical exam. They're also going to be looking at crimes and other like drug usage and things like that. So the consular processing, it has a little bit more risk involved, but it's important to be screened before you go. But for the most part, we find that people, if they entered legally and they entered one time and they have an immediate relative child petitioning them, then no other issues, then that is the best thing that we find. But that's usually not the common thing. We usually find is the individual entered illegally, has a US citizen child, and now is trying to figure out how to go about it. That's when we have to look to exceptions and alternatives and see if there is something available. So we're here for you. Feel free to give us a call at 713-589-2085. You can reach us on our website, rubypowerslaw.com. We're on Twitter, TikTok, Instagram, Facebook. Our newsletter comes out in English and Spanish every other week. And this month, we've had a lot of great webinars from PERM, filing mandamus, to what happens with your case after it gets dismissed in immigration court. And today's topic, can my 21-year-old US citizen child petition for me? If this was helpful, please feel free to send to a friend, a family, neighbor, someone where you worship or you school, wherever you want. But we want to be a resource for you. Definitely reach out to us if you have any more questions. And thanks for watching.